Let's begin our study of the criminal typology, although I'm unsure if that's the right word. Typically, students refer to manuals for concepts of typicality. We will continue in the next lesson. Now I want to concentrate on the concept of objective imputation. Because in some manuals, in an order or sense that seems super reasonable to me, it can be studied. They also study it within the concept of action, to finish explaining the concept of action and result. So that is why we are systematically going to start talking about objective imputation, and we are going to explain it according to the criterion that the majority uses, because there are many ways to explain it. It is an eminently normative concept that is under permanent construction. So what we're going to do is order the ideas according to the criteria of most doctrine. Current, let's say that it is objective imputation. It is the method through which criminal law imputes the result produced to its author. What is the basic formula? The result is only attributable to a person when he or she has created an impermissible risk that has been carried out in the result within the purpose of protection of the standard. What is the scope of objective imputation? They apply to all crimes of material consequence. Once the causal relationship has been proven, what are crimes of material result? Those of you remember that when we saw the classification of crimes, we said that, and we are going to explain the different classifications as we advance with the matter, explaining the different institutions, what crimes of material result are versus crimes of mere activity. Crimes with material result are those in which the result of the action is temporally separable. What is the result, the injury or endangerment of legal assets, and what is the action, the behavior that we studied in the previous capsule? So what is the scope and crimes of mere activity? What are those in which the space is not temporarily separated from the conduct, with the resulting example of a crime of mere activity, violation of address, or violates the address, or does not violate the address, or violates the address, or does not violate the address? It coincides. The result coincides with the action, an example of crimes with material results. Homicide is temporally separable space, the result of the action. You are thinking about a homicide. If you are shot in the head, the result will coincide with the action. But if I put poison in the cereal and you die a month later, it is temporally separable space, the death of homicidal behavior, for example. So what is the scope of objective imputation? Crimes with material result apply. Once the causal relationship has been proven, we are going to see how the causal relationship is proven. The first step to prove the result is then the verification of the causal relationship. Once this process is completed, the objective imputation criteria are applied. We are now going to study the background of the theory of objective imputation. He asks, when and how to affirm that the result is attributable to its author. Two questions arise from this statement. First, it must be established that a causal link does indeed exist, and secondly, it will exist. It must be evaluated whether or not it has criminal relevance. What is the objective imputation budget? The causal relationship. In crimes with a material result, the first challenge faced by the interpreter is to prove the causal relationship, that is, the link between the result and the action. To face this, the doctrine has developed different theories. What are these theories? Many, the two most important. The theory of equivalence of conditions, the so-called conditio sine qua non, and the theory of adequacy go in parts. Jack the Ripper said, causality as a condition, the theory of equivalence to conditions, the conditio sine qua non. According to this theory, any condition that has intervened in its production is the cause of the result. All the conditions of the result are considered equivalent, and that is why it is called equivalence theory. The theory uses the following formula, which is called hypothetical mental suppression. What is it? Is every condition causal? Which suppressed mentally would also make the result disappear. This is the formula, I repeat, that it is known as convictio sine. As an example, what difference does it make to kill naked or dressed? You make the condition disappear. I'm naked or I'm dressed, and I can still kill. But you can say the same in a violent carnal attack. For violent carnal access, it is an equivalent condition that you are naked or clothed. That's what it means. If you mentally suppress the condition and that causes the result to also disappear, there the condition is or is not equivalent, depending on whether the result disappears or not. What criticisms does the doctrine formulate to the theory of conditio sine qua non? First criticism, assimilate to the condition with a cause that every equivalent condition is a cause. Why is this criticized? Because causality leads to infinity. That is, any condition translates into a cause. Think about the next example we gave of homicide is an equivalent condition. That the murderer's mother gave birth to him? You're going to say no? Obviously yes, because when the condition disappeared, if the murderer had not been born, there would have been no homicide. So it is also an equivalent condition that the grandmother gave birth to the mother, that the great-grandmother gave birth to the grandmother, and so we get to Adam and Eve. So they take the absurdity of understanding causality to infinity. What other criticism can only solve cases whose solution is known from the beginning? So basically, more than solving problems, it complicates them. We go to the theory of adequacy. That in reality, more than a theory to explain the causal relationship, it is an incident theory of objective imputation. But let us cite them as if we had this theory. As within the theories that explain the causal relationship, they start from the following premise: not every condition is a cause. In the legal sense, but only that which is normally adequate to produce it. The judgment of adequacy is formed by the probability or objective predictability of the production of the result. That is, the condition is adequate if it is also adequate for the prudent man. From an ex post perspective, they see an impartial third party in the situation that found us prosecuted. Advantage restricts the scope of causality, prevents causality towards infinity. But there are more evolved theories of causation. Actually, like we said a moment ago, they serve as a basis for objective imputation by introducing normative elements into their assessments. We are now going to study how objective imputation is configured. Once the causal relationship is determined, not every result will be attributable to the action. Which ones are going to be imputable? Those who meet the requirements of the theory of objective imputation will do so. In other words, it is not enough to affirm the causal relationship, but we must also affirm the criminal relevance of the causal relationship. And what are the requirements of the theory of objective imputation? First, the creation of an impermissible risk. Second, the realization of risk in the outcome. And third, that is within the protection purpose of the standard. Let's explain them point by point. An objective prognosis governs here. That is, everything depends on saying what, whether an impartial observer before the ex ante fact would have considered that the behavior is. Or not dangerous. This is what is called the theory of going to the figure of the middle man. This average man, no, let's not understand him like civilians do. Sorry for the example. No, he's not Mr. Flanders from The Simpsons. He's not a very diligent person in the care of his most important business. Don't ask him so much. To the average citizen in the field of criminal law. For those of us who are 80s children, remember the figure of Canitro in The Happening with Jara, or for something more universal. I think a good example, Homer Simpson. That's the average man of criminal law. That's the unbiased observer we're thinking of, a normal person down, so to speak. He is not such a diligent person in the fulfillment of his business, in the care of his business most important. Let's go to the first criterion, the creation of an unallowed risk. In modern society, different modalities of risk are created at different times and under different circumstances. Criminal law is not interested in all risks. He is only interested in those risks that endanger or harm legal assets. If risk is allowed, if risk is tolerated, let us remember that we live in an eminently dangerous society. If the risk is allowed, a cause of atypicality is updated, and thus the unfair is excluded. How to know how we know? Permitted risks create relevant but allowable hazards, thus excluded from objective imputation. Legal systems, law of art, and historical evolution are three risk determination sources. Three sources for risk determination. And what are these sources? Firstly, the legal system. Secondly, the so-called leg artis, the law of art. And thirdly, the historical evolution of risky activity. Let's look at each point. The legal system is the most solid source. And reliable for what? To determine the permissibility or not of a risk. It is most likely that the analyzed behavior finds the rules for its execution outside criminal law. For example, traffic.